It is very easy to have a general mantra in a criminal case. The offense is a heinous offense, therefore there shall be no bail. We also know that sometimes informants tend to over-exaggerate a first information report. The judges at the grassroots don't understand the crime. That if I grant bail, will somebody target me tomorrow on the ground that I granted bail in a heinous case? Bring to our district judiciary a sense of dignity, a sense of self-worth, a sense of confidence in their own respectability, which is why I always say that our district judiciary is not a subordinate judiciary. It is really the district judiciary which is equally important in the affairs of the nation's judiciary as of the High Court or the Supreme Court. The Supreme Court may lay down these big ticket judgments, as they called, important issues which are decided by the Supreme Court. But the district judiciary in those small cases, they define the peace, the happiness, tranquility, and faith of common citizens. The way we look at the district judiciary affects deeply our own personal liberty as citizens. If district judges do not have the confidence in their own abilities, in their own respect, in the hierarchical system, how would we expect a district judge to grant bail in an important case? It is very easy to have a general mantra in a criminal case. The offense is a heinous offense, therefore there shall be no bail. This is an offense involving murder. This is an offense involving rape. So there shall be no bail. But we know as judges, and you know as lawyers, that even within that category of cases where the offense is heinous, there may be a tendency to rope in somebody who is not exactly guilty. We also know that sometimes informants tend to over-exaggerate a first information report. Now, how do you sift those who may be guilty from those who may possibly not be guilty? That is the art of the district judge himself, and that is what the lawyers have to point out to the district judiciary. And it is when we do this common mission, the higher courts are getting flooded with bail applications. I've just taken a decision as Chief Justice of India that there are 2,000 bail applications pending in the Supreme Court, 3,000 transfer petitions pending in the Supreme Court, 5,000 out of the total pendency. So we decided at the full court meeting the other day that all benches of the Supreme Court will take 10 bail applications every single day. The idea being that we have 13 benches today. So 130 bail applications will be disposed of, 650 at the end of 1 week. Hopefully at the end of 4 weeks we would have, of course there will be fresh bail applications. But this turnover has to constantly be maintained of matters which are filed and matters which are disposed of. But the reason why the higher judiciary is getting flooded with bail applications is because of the reluctance of the grassroots to grant bail. And why are judges at the grassroots reluctant to grant bail? Not because they don't have the ability, not because the judges at the grassroots don't understand the crime. They probably understand the crime better than many of the higher court judges because they know what crime is at the grassroots in the districts. But there is a sense of fear that if I grant bail, will somebody target me tomorrow on the ground that I granted bail in a heinous case? This sense of fear, nobody talks about, but which we must confront. Because unless we do that, we are going to render our district courts toothless and our higher courts dysfunctional. One of your members from Varanasi just gave me a very beautiful statement written in Hindi this evening, that why is the High Court of Judicature at Allahabad flooded with bail applications? Should these applications not be considered by the district judiciary? But the reason for it is the culture of distrust which we have generated amongst ourselves. Why should we distrust any person who grants relief to a citizen? If you commit an error, surely that error is amenable to correction. And it's not that we in the Supreme Court never commit errors. As they always say, the Supreme Court is not final because it is right, but it is right because it is final. So the process of dispensing justice is so intrinsically human that we have to learn to trust our district judiciary. Because it is when we learn to trust our district judiciary that we will truly answer the needs of our common citizens who seek access to justice.